Good morning.
Morning, Your Honor.
Good
We
morning.
Good morning. We are here on case number 233371, Schultz versus Johnson. As you all know, we're here for an oral argument by Zoom. I am Harvey J. I have the honor of presiding today over this Zoom oral argument. I also am here with two of my esteemed colleagues, Judge Makar, also from Jacksonville, and Judge Joe Boatwright from Palatka. The beauty of this service allows us to all be here together. Please be mindful, this is Zoom. I know there are vagaries with this that we don't necessarily have in the courtroom. If you have not muted your microphone and you're not speaking, I would ask that you do that, just so we don't have added verbalization while the advocates are speaking. Also, as to the appellant, typically time is set aside, typically 5 minutes is set aside for rebuttal. Who will be presenting for the appellant today?
Your Honor, I will. My name is Patrick Roach, and I represent Lorraine S. Schultz.
All right, Mr. Roach, would you like to reserve any time for rebuttal?
Yes, sir. I would like to reserve 5 minutes.
All right. If you are ready, you may proceed.
Thank you. May it please the court. Your Honor, I'll first address count one of the plaintiff's or appellant's complaint, which stated a cause for intentional infliction, for tortuous interference with an expectancy. As the court knows, there are four elements to that particular tort. The first element is an expectancy. The second is a tortuous or wrongful interference with that expectancy. The third element is causation, and the fourth element is damages. In the order dismissing count one with prejudice, the trial court found that the appellant had only satisfied one of those four elements, that being expectancy. It is our contention that the judge erred in that because there was ample alleged ultimate facts to support that particular cause of action. According to the appellant's complaint, she had an expectancy as to receive at her father's death substantially one half of his considerable wealth. The complaint also alleges that the father revealed his intention to both the appellant and an appellee, who was the appellee being the father's son, only son, they being the only two children. In separate telephone conversations between them, he disclosed that he would both the extent of his wealth and his intention to treat them equally in the distribution of that wealth. Further, the complaint alleges that the intention by the father was a long-standing one, going all the way back at least to 1996 when he established his trust. He established his trust. The complaint also alleges that the father...
Counsel, if I could interrupt and ask a question.
Yes, sir.
The existence of an expectancy is not in dispute, correct?
No, sir.
Okay, so what you're reciting now is about the existence of an expectancy, but that's not in dispute. So two quick questions. One is procedure, one substantive. Excuse me. The overall case, the dispute in the courts was initially filed in Sumter County, right?
Yes, sir.
And your client brought cross claims and counterclaims.
Yes, sir.
Okay, and then the number of iterations of that were there motions to dismiss and so forth. So I don't recall whether there's two amendments were being made by your client or not, but a couple of them at least, right?
Yes, sir.
Okay, then your client dismisses from that action and files the complaint that's before us today.
Yes, sir.
In Brevard County.
Correct.
Okay, and then that case was then transferred back to Sumter.
Correct.
Okay, but essentially the operative factual allegations are essentially the same or have evolved throughout the process here. So what we have today before us is not the first complaint in the sense that the first time these allegations have been made. They were made in the original Sumter County case. They were modified, and then your client dismissed. And now what's before us is this new complaint, correct?
Yes, it's the same complaint that was filed in Brevard County.
Okay, great. So I just want to make sure, because when I first looked at it, I thought, well, everyone gets to amend their complaint once, essentially. But this is actually about the third or fourth amended complaint that we have before us in effect.
Yes, sir.
Okay.
Well, it's convoluted because the court in Sumter County dismissed the appellant's cross claim and her counterclaim. The Brevard County case, she decided not to go forward with her counterclaim. I mean, her counterclaim. So the cross claim that was filed in Sumter County is essentially what is in the Brevard County complaint. The four counts.
And that's what's before us today.
Yes, sir.
Okay. On the substantive question, the second element of the tort of intentional interference with expectancy is there has to be some intentional interference with the expectancy through tortious conduct.
Yes.
And that's where I think I have some concern, because the allegation, basically stripped to the core, is that there are in the background some text messages that were shown to the decedent, the father, who got him enraged and thereby halted the trust proceeds to his daughter. Those text messages are not on the record, correct?
No, they're not in the record.
Okay, so and the only allegation is that in the complaint it says that Johnson, the son, presented his father with sheets of paper which he told his father contained the contents of numerous indecent and offensive text messages,
correct,
which purportedly came from your client.
Correct.
Right?
Yes.
So that, unless there's something else there, that's essentially the core of the alleged tortious conduct, correct?
Well, yes, it is. We're alleging that the appellee fraudulently represented this alleged misconduct on the part of appellee with the intention that would alienate him from his daughter to such a degree that he would alter the terms of his trust in a manner that was favorable to himself. So we're alleging fraud, that the appellee interfered with the father's estate planning, longstanding estate planning, through fraud in order to enrich himself and at expense of the appellant.
But the only tortious conduct is what I've just described from the complaint, the allegedly false text messages.
That's right, the fraud, I guess.
Right. Okay. Was your client actually removed as executor of the state 25 years ago?
I went and researched that yesterday, and we can't verify that, whether she ever was. If you look at the amendments, if you're referring to that email.
Yeah, on page 14 of your complaint.
If you're referring to that email says, among other things, that my client was removed as executor. If you go back to the trust instrument, that was in 1996. And if I remember correctly, in 1996, the trust agreement provides that the appellant and appellee would be co-executor, would be co-trustees as a co-successor trustees. And then the two amendments there to the first and second, I believe, if my memory serves me correctly, the appellant was made the alternate co-trustee or successor trustee as an alternative to her brother, the appellee.
Okay, well, I guess what I was concerned about there is there's this long text messages purportedly written by the mother to the daughter that was uncharacteristic of the mother in terms of tone and language, but the complaint doesn't say it's false.
I think the claim is that the mother didn't write it.
Right, right. Which, I mean, that may or may not be accurate or not. We just don't know. But I'm guessing what I'm saying is that I didn't see anything in the complaint where your client said this, the contents of this is false. So you're not using this, and what I'm getting at, you're not getting at using this communication as being false and fraudulent.
The purpose of that communication is to show a pattern of conduct on the part of appellee that we believe was the source, among other things, was the source of that's there to support the intentional infliction of mental distress count.
Right.
Count two.
Okay. All right. Thank you.
Sir, to follow up on Judge Makar's question, do you know the content of the original text messages?
The problem is that there are text messages, and we don't have those papers. We don't have the papers. The papers never came into possession of our client. The client's father told her he had been delivered to him by the appellee, and I don't think I think the if I remember, the substance was they were sexually suggestive about the appellee's daughter, Madeline, who I think was at summer camp at the time and was only 14 years of age. But we're not in possession of the actual alleged text messages, which weren't on a phone or anything. They were just on pieces of paper that he represented to his father, were text messages that our client had sent to Madeline, the daughter.
Isn't that a feature though? I mean, if you don't know with specificity what's in those text messages, isn't that a real problem for this claim? If that is the predicate, the foundation of this claim, doesn't it matter whether or not you know the substance of what was in those text messages?
I think the essence is, Your Honor, is that is the reaction of the father, which is well stated in the complaint. Whatever the content was.
And I appreciate what you're saying, but his reaction sort of begs the question. I mean, back to what Judge Makar was saying, there has to be tortious conduct. I mean, that's part of that second element. So if the whole basis of this purported tortious conduct lies in those text messages, don't you need to know what was actually said? Not his reaction to it, but what was actually said in it to meet that hurdle, the tortious conduct hurdle.
Well, the father said they were indecent. They were indecent accusations about a young girl. I think that's an approximate quote from the complaint. So, and that we represent that never happened. We say in the complaint that our client never sent those text messages. They were a fabrication, and they were therefore fraudulent. They never happened. That's what the complaint says. That they were false and fraudulent. They never happened. Whatever it was, the father said they were indecent allegations about a young girl. Court have any more questions? At that point, I'll end my presentation here, Judge, with reserving my 5 minutes for rebuttal.
All right, thank you, Mr. Roach. Response from the appellee?
Yes, may it please the court. My name is Dave Hathaway, and I am the attorney for the appellee, Richard D. Johnson, both in his individual capacity and as trustee. This is really a case about the limits of suing a sibling over a family controversy that results in a near complete disinheritance. I believe there are really two key points to be made by the appellee in this matter. One being that the 4 causes of action are not supported by the allegations in the pleading. Therefore, I believe they were properly dismissed with prejudice. And secondly, as the court noted, these matters have been pled 4 times. And as stated in my brief, there's case law stating that typically after a third amendment, a dismissal with prejudice is not improper.
Mr. Hathaway, where is that in the rule of procedure? Well, 3 times and you're out, 4 times and you're out.
Yes, you're right, Your Honor. It's not in the rules of procedure. It's just under the case law, and it's the Lifschultz case.
And I know what the cases say, so it's not in the rule, correct?
Correct.
So it's judicially implemented, as far as how many times is too much. But doesn't that, so you would agree with that, correct?
I do agree.
Really, our analysis tree is looking at this case. Every case is different, and 2 times may be too many, and 5 times may not be enough. You would agree with that, just depending on the facts of the case.
I do. I think it's a case-by-case determination.
So why here, you said 4 times, why was that enough in this case?
Yes, Your Honor, there have been 4 trial court judges who have signed orders in these matters. The allegations are roughly the same in each of the sets of pleadings. There may be more detail in the later sets of pleadings, but I believe the core allegations are substantively the same among all 4 sets. And that's why I believe that it's really 3 amendments plus the original set, so 4 sets of pleadings. Or really, let me rephrase that. A set of cross claims and counterclaims, first amended cross claim and counterclaim, second amended cross claim, and then a new complaint in Brevard County. That's the best way to answer that. So let me turn back to my first point, which is, well, first of all, this is a standard de novo, so the court obviously is entitled to make its own determination from the start and not rely on any decisions by the trial court judges.
Mr. Hathaway, why isn't the tortious interference sufficiently pled? I mean, the appellant's alleged fraud, that these fraudulent text messages were sent, and then that caused the father to disinherit his daughter. I mean, why isn't that sufficiently pled? This is just at a complaint stage. Maybe it seems a lot what you're arguing might be something you can argue later in proceedings at summary judgment, but why isn't this sufficiently pled?
Yes, Your Honor, I believe it's not sufficiently pled because a fraud claim requires that the person who's misled rely on that misinformation to his detriment. And that's not really the crux of this type of lawsuit. In this claim, the allegations are that my client misled his father about the text messages. His father didn't lose any money over that. His father then confronted Lorraine and asked her point blank about this issue. So this was not done behind her back. And then ultimately she alleges that she lost her inheritance, although obviously no inheritance is guaranteed. And of course, the spouse survived the husband, so theoretically she could spend it right down. So I think the best way to answer that is there's a problem with the fact that the person who received the misinformation is not the same person who suffered the loss.
Is that the extent of your argument on that issue?
Well, there's a lot more. I mean,
I guess my point is, isn't it has to be like at least at the fringes of fraud for someone to fabricate text messages or emails and then present those with the intent to deceive someone? That does seem to be fraudulent, regardless of who in the end gets hurt by it, whether they have a financial harm or not. But that's the whole point of this tort claim, is it isn't that the the father lost any money. It's that, the plaintiff lost money because her inheritance, her expectancy, everyone agrees there was an expectancy there. I think everyone agrees that, that's what she lost that. So I guess what I'm getting back to is, if text messages were attached to this that were fabricated and false, wouldn't this complaint survive a motion to dismiss?
Your Honor, I still don't think it would survive because it's ultimately what the parent decides to do with the information. That parent could have turned back to Richard and said, Richard, stop it. Or Richard, I've known Lorraine for all her life, and I'm not going to, rehash old topics or things that happened many years ago. So
With respect, I don't understand that point. I don't understand why, the idea that the dad could believe it or not believe it, that's sort of a decision point in deciding whether a claim has been stated here. I mean, it doesn't say that he had to believe anything.
yes, Your Honor, I think that's, I think that the issue with this case is that it sounds like the text, if you accept what's been alleged for purposes of a motion to dismiss, the conduct sounds improper to me. I don't believe it meets the elements of fraud, and I also don't think it's tortious interference. Now, those are two different causes of action with different elements. The proximate cause for the tortious interference, it's how the father reacted to that and what he decided to do. And I think it's important that this is an estate planning document. Estate planning documents typically are attacked in two ways. There's typically unjust enrichment claims or lack of capacity claims. And a parent doesn't need to have a good reason to make a change. A parent can make a mistake, but it's not up to a trial court to second guess.
Well, it seems to me you're talking about causation. In other words, let's say she had met the first two elements here. The causation issue would be, well, did this communication that was false, fabricated, and so forth, did that cause the dad to change his mind? Apparently, it looks to me like he did, based upon what was alleged here. So you're talking about causation, but I'm still focusing on that second element. I'm a little troubled because it seems to me a classic interference with expectation type of claim is one where a sibling creates some falsehood to deceive the mom or dad into making a decision in his or her favor and against the other sibling. Right?
Well, Your Honor, on that point, really the typical case of tortious interference with an expectancy is like where someone's circumvented an estate plan, like somehow obtained, let's say, a bank account, joint tenants with right of survivorship, or improperly obtained a deed to a property. That's the typical type of tortious interference with an expectancy because it's during the person's lifetime. To challenge a document, an estate planning document, the key question is, was this the father's decision or was it Richard's decision? And in this case, although the facts sound sad, it sounds like this was the father's decision, and he told her that he wanted that you're out of the family if you don't confess. Whether she could have mitigated the situation, gone to lunch, talked about it, I don't know, but I don't believe that that is tortious conduct to present sheets of paper, because I also believe that this sort of thing happens frequently in families.
Mr. Hathaway, isn't
Yes,
what
sir.
you're arguing, though, something for a fact finder? You're starting to make factual arguments here about what people thought. I mean, again, it goes back to why is this not proper? I mean, it seems they've made out a proper allegation. Are you saying that there's factual disputes at this point? Is that why you think this should be dismissed?
I do not think there are factual disputes at play right now. I think that the pleadings have been, Judge Hallman essentially wrote in those orders that Lorraine is making conclusory allegations about what caused her to be disinherited. And
Well, let me ask you about that, Mr. Hathaway. If that's the predicate for this, this judge is not sure that's a bad enough thing. Because if it's just conclusory, their cases are legion, that they should have another chance to replete it. Now, if you're saying this can never be pleaded, and allowing them amendment would be futile, that's a completely different paradigm. But if it was conclusory, that's not a bad enough thing in this judge's mind to dismiss a complaint with prejudice. So are you telling us that was the reason it was conclusory?
that was the reason it was originally dismissed. However, the reason it was dismissed with prejudice is due to the procedural background. And I'd also point out that throwing out an amendment to a trust after someone's death really requires a finding of destruction of free agency, destruction of willpower. It's a document that only the child wants and the parent does not. And that's kind of the opposite of what's been pled, and I think that's the issue.
Well, I can tell me, counsel, typically, if my recollection is correct, a fraud type of theory or fraud type of claim in Florida has to be pled with specificity. Was that a part of the discussion below, or in your? I don't recall if it was in your brief or not, but it seems to me that that concept, fraud has to be pled with specificity, may play a role here.
I would agree, Your Honor. I don't think it was briefed very much, the specificity. I don't remember seeing that in, it might have been somewhere in one of the briefs in the record, but I don't believe it was in an order. And I agree with you, Your Honor. It's not specific as to what allegedly was said, what was allegedly relied upon. And it doesn't say that my client told his father to change his estate plan. The documents do show that my client is a Illinois resident, whereas his father lived in Florida. So all the typical factors that you might look to in determining whether someone actually was making their own decision or whether they were being overtaken by someone else, those would be those Carpenter factors in an undue influence case, which show that the Florida courts really look at, has the child interfered by, recommending the attorney?
Mr. Hathaway, is this a claim of undue influence? I thought he was claiming fraud.
Yes, correct, Your Honor. It's not an undue influence claim. The way I understand the pleadings, it's fraud. But my point was just that the tortious interference claims are not typically brought to overtake an actual testamentary document. And so, going back to a couple of other points, and I'm not sure if that 5 minutes is that my 5 minutes, or do I need to stop now?
Well, there's no rebuttal on the appellee's part. So you have 5 minutes and now 18 seconds, Mr. Hathaway.
All right. Thank you, Your Honor. The third amendment to the pleadings also indicates it was the same attorney who prepared the trust in 1996, the amendment in 1999, the second amendment in 2009, and the final change in 2019. And Your Honor, it also says in the pleadings, it reveals the date of death. The date of death was 2 years, approximately 2 years after the third amendment. So if the decedent felt as if he'd been too impulsive, or if he acted out of anger and then cooled off, there's no reason why he could not have driven back to his attorney's office and changed the decision. And I also just want to make a point about the slippery slope. there are many times where trust and estate litigation involves a sibling who receives a lesser share than another sibling. And I worry that if a claim like this stands, where a disappointed beneficiary can allege that her brother caused a rift in the family, I think that's a slippery slope for Florida law. And and I'll just wind up, I see I have a few minutes. I believe that because, the court is obviously focused on count one, but counts 2, 3, and 4 really emanate from the same problem with count one. And I just want to just be clear that the appellant had, 4 chances to plead this. If there was more to say, you would think it would have been said. And it is a very detailed complaint. It's just that there's no specifics about what allegedly were in those text messages. It was August of 2021 when the first pleadings were filed as counterclaim and a cross-claim. We filed motions to dismiss. It was October 5th of 2021 with the first amendments to the counterclaim and the cross-claim. The first amended cross-claim was then dismissed with leave to amend. It was December 17th, 2021, when the second amended cross-claim was filed along with a notice of dismissal, a voluntary dismissal without prejudice, which was unusual because you would think if you're voluntarily dismissing without prejudice, you would just take that new pleading and throw it in the trash can. But it was filed, so we did respond to the motion, the second amended cross-claim, and there was an order ultimately dismissing the second amended cross-claim. And then it was, while that was happening, it was December 23rd of 2021 when the new complaint was filed in Brevard County. So there have been, 4 sets of pleadings. It's been tremendously time intensive. There were many other motions and orders actually about.
Counsel, could I ask one final question?
Yes.
I asked the counsel the other side on page 14 of the complaint about the email from the mom to the daughter saying, 25 years ago you were removed as executor, 12 years ago you were removed as medical proxy, and so forth. Is there anything in the record or otherwise that judicial notice could be taken of that those things are accurate?
I do not know of anything in the record that states that. Only the trust and the amendments, as far as I know, are in the record. So I do not know the answer to that question.
Okay, thank you.
And so we would ask that the court please affirm the trial court's decision in a dismissal with prejudice because of the 2 main reasons. One being that the allegations don't meet those elements of the various claims, and 2 being that there are already 4 sets of pleadings. And thank you very much for your time.
Thank you, Mr. Hathaway. Rebuttal, Mr. Roach?
Yes, Your Honor. What's being overlooked here, I think, by counsel is the fact that this is a complaint. When he talks about a slippery slope, this is just a complaint. It's not. Counsel argues policy, but we're just trying to get a complaint. We're not going into. It's not as if we're going to trial on this at this point. It's not a slippery slope, and it's a complaint. I think we've met the requirements to plead all 4 actions in the complaint. And what's been argued by counsel and I think maybe the trial court too, to some extent, is facts, disputing facts. I think that the learned judges committed error because they didn't give us the benefit of those inferences, which we were entitled to in the context of the review of the adequacy of a complaint. Counsel just argued about the fact that the appellee lived in Illinois and the father lived in Florida. He also brought up the fact that The father could have changed his mind because he didn't die for a couple of years after that Third Amendment. Those are facts. That's appropriate in the context of a trial. For the trial, those are things that are for the trial, the finder of the fact to resolve, and not germane to this court's review of the adequacy of the complaint. The court brought up the fact that fraud is required to be pled with specificity, but I think that's more like a financial transaction, where it has to be pled like that. Here, what we have is interference, fraud resorted by the allegedly by the appellee to frustrate the father's estate planning, to interfere with it, to tortuously interfere with it. If he presented false representations to the father concerning the alleged conduct of the daughter, with the intent that that father would rely on that and disinherit the daughter in his favor, I think that's classic fraud in the context of this type of action. I think in our briefs, we referred to the seminal case of Bohannon versus Wachovia Trust, Inc. That's the case that was adopted by a number of courts to sanction this particular tort in Florida. And in that case, you had a grandmother and I believe an aunt make fraudulent representations about the son, the grandson, that caused the grandfather to change his long-standing fixed intention to make him the beneficiary of his will. That's the classic essence of this tort, the interference with the testator's intent. And the Bohannon case doesn't tell us what those representations were, just tells us they were fraudulent and that those representations were sufficient to sustain that type of action. So we think we've satisfactorily pled all 4 counts as far as pleadings are required.
Mr. Roach,
Yes,
Mr.
sir.
Roach, is Mr. Hathaway correct that what the beneficiary is doing is suing to recover damages primarily to protect I guess here would be the settler's interest. It seems in the case law that he cited, it's not really the disappointed beneficiary's expectations. You're doing this for the benefit of the settler. I think that's what kind of Mr. Hathaway argued in his brief. So can you address that? How to actually protect the settler's interest in this matter rather than your client's disappointment?
Well, that's said in the cases. It's an extensive case on this tort, and we cite them in the briefs. That is a derivative. I think they say it's an unusual tort in that the person who's disappointed heir or beneficiary is really bringing his action to vindicate the frustrated intention, estate planning intentions of the settler or a testator. But also, in that one case we far in a brief, there says there's an exception to that, and that's a case where there's the fraud that's resorted to by the malefactor or alleged malefactor is defamatory. In that case, and that's referred to in the brief, you have both the frustrated intention of the testator, but you also have defamation against the disappointed beneficiary.
Counsel, has there been any mediation in this case?
No, sir.
Okay. And is the Ms. Johnson is still the trustee?
Mrs. Johnson?
Yeah, who's the
Mrs. Johnson is deceased.
Okay.
So
So it's the
now
son now? Is it the son now?
the son is a trustee.
Okay, I got you. Because I guess at the time the complaint was filed, she was listed as the trustee, but she's now
Correct.
Okay. All right, thank you.
Well, if you don't have any more questions, I would thank the court for its time.
Thank you, Mr. Roach. And with the end of the argument, that's the end of this session. We will be in recess. Thank you both for your presentations.
Thank you, Judge.
Thank you, Your Honor.